So what we do now is we move on to the essence of what we do. Are these phrases that ring a bell with you as trust lawyers? The dispositive and the administrative provisions of the trust deed? The significance of that will come out a bit later, but there are two quite separate and distinct, I guess, areas of the trust deed. The dispositive provisions, how the trustees get rid of assets or deal with them. And the second one is how a trust is administered. And sometimes it's difficult to understand or to interpret which is which, but I've tried to give some sort of prosaic discussion or example there. Dispositive means actually you're dealing with an asset and it may well end up outside the trust, so it's come to an end. It's no longer a trust asset because it's been disposed of one way or another. The second one, to use that, very overused slide now, it's how the trust is managed and administered. And so I think it's important that we understand the different aspects to the trust because, again, a lot of non-trust lawyers don't understand these nuances. And unless you understand what these mean, sometimes you don't know what other clauses, how they work as well, and how effective they might be. And again, that's a teasing sort of statement there, but it will come back in a little while, hopefully to make more sense. So dispositive powers. The trustee's powers and discretions as to how the trust fund is to be paid. Fairly straightforward. One of the interesting things that's often mistaken is when you talk about trust appointments. And to the lay person, it usually means appointing somebody as a trustee or as a beneficiary or something. But in trust terms, appointing trust assets means you actually dispose of them. And the power of appointment is the person who has the power of appointment is the person who has the power to decide who gets certain assets. And we'll come back to that again in a little while. But it's important to understand, in particular where there are perhaps claims or litigation issues arising and people talk about power of appointment, are they talking about the right thing in the context of the issue at hand? An example of a dispositive power I've got there from a clause, the trustee shall stand possessed of the trust fund upon the trust and with the powers in this deed. So that gives the trustees the power of appointment of trust assets. So that's a fairly important distinction when you're drilling down to the subtleties of trust law or estate law. Who gets the powers to deal with the assets? And we all know in generic terms that the trustees are the ones who are charged with the management and administration of the trust. But sometimes you might see different powers where it might say the trustees or give, or perhaps with the settlor's consent, can dispose of trust assets. In that case, the question, who's got the power of appointment? Is it the trustees? Or because the settlor has a power of veto, do they have the power of appointment? And that will become important, obviously, if you think back to Clayton and Clayton type situations. Who has the power to control or dispose of assets? If it's the trustees, is it an unencumbered power and unfettered, or are there limitations as to what they can do? And you often find non-trust lawyers, commercial lawyers in particular are the worst, who draft trust deeds, will put in all these clauses that the trustees have absolute power to do anything they want subject to obtaining the power or the prior informed consent of the settlor or something, or somebody else. And they don't realise that what they've done is they have then fettered the trustee's discretion, which then starts to bring into question the effect of the discretionary trust, because the trustees actually haven't got discretion because they've got to always bow down to the decision of somebody else. So if you're drafting a trust deed, the question is, and the client says, I want to make sure I've got power to veto everything, Well, have you really got a trust deed at all? Or, sure, we can do that, but you need to be very aware that because you have watered down the trustee's powers, if this is challenged, there's a very real risk, they say, that actually you still hold the controlling influence. And it's Clayton and Clayton all over again. So it's subtle drafting techniques, but can have a huge impact on the effectiveness of the trust. So you will have seen these clauses in your trust deeds, that the trustees have the power to pay, apply and pay over. Are they familiar wording? And pay over, what does that mean? It's not like just paying over money to the beneficiary, it's obviously paying for the benefit of them. Some trust deeds will say that the power extends just to capital. And how many times have you seen trust deeds with those restrictive clauses? And usually they're older trust deeds, in fairness, but they're limited to capital and not income, or vice versa. You can only pay out the income and not the capital. And that's when the scrutiny arises, when there have been these peculiar drafting techniques where there are limitations, and you look back at your accounts to find out actually what's happened in the last 15, 20 years, especially if you're being asked to come on as a new trustee because the other trustee is retiring or getting old or died or something. What's happened in the past? And have there been any problems because you can only distribute income during the lifetime of the trust with all the capital then going to the residual beneficiaries, but they've actually been paying out capital as well. And the general provision these days is that you can pay out both capital and income under during the life of the trust. In your trust deeds, do you have separate clauses for dealing with capital and separate clauses for income, or do you have a clause that just says the trustees may, during the life of the trust and at the discretion, pay, apply and pay over such the capital and or income as the trustees think fit? Or do you do a separate clause, one dealing with income, and you can apply income first against charges, costs and expenses, and then that which hasn't been used can then be distributed? My preference is to separate it out. I have one clause dealing with income, one dealing with capital. But as long as it's clear, if it's just going to be a carte blanche ability to deal with all of the assets, that's fine. You can probably get away with one clause. But my drafting preference is to deal with each issue on a separate basis, because to me, I'm just a simple soul. It limits the risk of getting confused or perhaps vague. If I'm dealing with one issue at a time, I can give it more attention and make sure that there are no subtle influences that I have overlooked. So I always split my capital clauses and my income clauses, but it doesn't mean it's wrong to have capital and income clauses joined together. But make sure that the clauses that you're using are effective for what you want, because in particular older ones, and if you're coming from a firm where it's just rolling out old precedents, just check that the old precedents are still relevant to today. So these are some other dispositive powers. The power to terminate the trust. So obviously if the trustees have power to bring forward the vesting day, it means the trust is going to come to an end earlier, and the trustees are therefore determining to pay out the trust fund, bring it to an end and pay out the trust fund in accordance with the final vesting provisions. Conversely, continuing the trust, because you obviously you're keeping the money going, keeping it going. And then the method, nature and extent of payment. Your income and capital clauses will no doubt have very broad discretions there, and no doubt includes the phrases that the trustees can apply the capital or income to such one or more of the beneficiaries as may be in existence at the time for the housing, clothing, maintenance, general benefit or enjoyment in life of the beneficiary. Interestingly, I've seen clauses lately which I think people try and make it a bit more modern, and they've left out some of those aspects, and they don't actually have the general catch-all for the benefit in life of the beneficiary, which means sometimes you've got to question whether the distribution that's being asked for is consistent with the terms or the powers under the trust deed for which the funds can be distributed. If it's just for the housing, clothing, maintenance, education of the beneficiary, it wouldn't cut it for buying a new car or for going on a trip or something like that. And I think it's fair to say that that sort of distribution is not a problem because the trust is there for the benefit in life of the beneficiaries. And if they've transferred all their assets to a trust, or most of their assets to a trust, and it's there to protect and preserve, they've got to get benefits. So sometimes there will be a distribution of funds out to buy a new car or to do something. But I have seen trust deeds where they can't do it because the powers have been modernised and as a result of that restricted. And that's, I've found that junior staff sometimes like to make their impact on their role and say, oh look, I've done these documents, but hopefully they'll tell you where they made the changes to them. And I've had to tell juniors, I said, actually, don't change my bloody precedents because they're there for a reason and they work. And if you change them, I've got to sit there and work out, is it still effective? Does it have the same effect? Does it cause any other problems? And if you've changed that one, geez, have you changed any other documents and not told me? I've got to check everything you do with a fine-tooth comb. Stick with the bloody precedents. If you've got a question, ask me. Let's discuss it. And if there's a good reason to change it, let's do it. But don't just do it of your own volition because you think it's a good idea. I'm the experienced one here. And it doesn't mean I'm not closed off to ideas because you learn something new every day. But for God's sake, tell me what's going on and let me know. And then we can work it out. Because things do evolve and change. And different experiences from different firms and different practices can help to improve precedents. You'll find in your own practice that your standard template changes from year to year because there are subtle changes that you pick up from one client's circumstance. You think, actually, yeah, good idea. And you just do a little tweak. And that's great. And we've got to be open to that because these are dynamic arrangements and dynamic documents. But controlling the document is an important aspect so you understand what's going out. And then obviously the power of appointment selecting which beneficiaries to pay. Again, clauses these days are pretty broad, any one or more, to the exclusion of others. And obviously some of the standard principles of trust law that people misunderstand is that trustees are meant to be even-handed as opposed to treating beneficiaries equally. And some people think that if you distribute 5,000 to one beneficiary, you've got to distribute it to all beneficiaries. Well, that's completely wrong. Treating beneficiaries equally is not the same as treating them even-handedly. And again, we come onto that in another module. But subtle little things that some people just don't pick up on. But it's important when you're speaking with your clients to explain to them, actually, because of the flexible nature of trust law in New Zealand as it now stands, we are able to select any one or more beneficiaries to the exclusion of others and give them the benefit of funds or distributions. And that's what a lot of clients want to hear, is that they can still get access or have available to them for their enjoyment in life the benefit and the assets of the trust fund. Can you think of any other powers not listed there that might be dispositive in nature? This is the interactive part, you see. I can just do a tick, then I've done one interactive question. Yep. Resettlements. And I quite like that little, I don't know if you can read it up the back there. Perkins, the correct term for this operation is a transplant, not a cut and paste. And resettlement, again, you probably all know about these, but we are in effect moving assets from one trust to another. And how do you explain that to your clients? What does a resettlement mean? In terms they understand. And they say, well, why can't you just distribute it out or something? And I say, well, the benefit is that really, if you do a resettlement, the asset continues to enjoy trust protection throughout. It's never lost. The significance of that is if you're going to do it by way, and sometimes you can't do a resettlement because there are just restrictions which prevent you from doing so, and you'd have to do a distribution and then a new settlement onto a new trust. If you have to go about in that way, the problem is that once you distribute it into an individual's hands, the clock starts running for potential insolvency clawback, and that's up to 5 years. Depending how it's used or why it's used, the litigators might try and grasp onto it for creditor issues. If somebody goes into insolvency, that they've had assets, gifted them away to a trust, so the insolvency aspect comes back. It might be that for PRA issues, that it's argued that it's a disposition trying to defeat a spouse's intention, a spouse's rights there. What are the rights in respect of a distribution from a trust? Well, we all know that the PRA says that when you receive an inheritance, it's your separate property unless and until you use it for the benefit of the relationship. But there are always questions that there are grayness of these things, and to me it's better not to go there than to have to fight about it afterwards. And it's always infinitely better subject to tax rules that you resettle rather than distribute and then settle onto a new trust, because you get the continuity of protection. Does that make sense? So if they're the dispositive powers, the next exciting part is the administrative powers. And this is where we start to, we're peeling back the layers of the onion here. We're getting down to the basics of the trust deed. So I reckon there are two aspects to the admin and management of a trust. What the trustees are authorised to do and what the trustees are required to do. Quite separate and distinct concepts. So what the trustees are required to do is basically what they have to do under the trust deed and by law. Any guess as to what those sort of mandatory things might be? Let's interact with question number 2. And now, remember I said that I'll have a few photos that probably look a bit obtuse or you can't quite work out what they mean, but when you see them, they might resonate. Ready? Yeah. What are the trustees' core duties? Yeah, exactly. So, core duties are things that the trustees have to do and cannot contract out of. And as you said, there we go, Armitage and Nurse. The irreducible core duties. To act honestly and in good faith for the benefit of the beneficiaries, the minimum obligation necessary to give substance to a trust. And these sort of issues become incredibly important when, in particular, commercial lawyers try to restrict a trust deed to provide commercial effect to their transaction, but they want to use a trust. And they never consult a trust lawyer. They just draft their trust deeds and they commercialise them, and what they end up doing is creating contracts rather than trust deeds without realising it. And I'm pretty sure from memory that the Clayton and Clayton trust deed was drafted by a commercial lawyer at one of the big law firms. And you can understand they're trying, he was a big, was a sawmiller and timber miller and big businessman, wanted a big firm, commercial lawyer, cranked it, I can do a trust deed, cranked it out, and gave everything to the client that the client wanted, but didn't really realise that in doing so they probably compromised the integrity of the trust, which we all know was the case. So understanding the minimum obligations necessary to give substance to a trust is what it's all about. And your trust deeds, hopefully, have a boilerplate template that include all of these basic provisions. Some examples of those core duties: to act even-handedly between beneficiaries. And I highlight again, that's different from acting or treating beneficiaries equally. To act with reasonable care. This is one of the hardest ones, to avoid conflicts of interest. How many of you do work where you may have set up a trust for parents, but you've now been so good at that work that the children have come to you and you do work for the children as well? And potentially there are conflicts of interest. Actually, have ever any of you come across a situation where parents want to appoint their children as trustees? What do you do in that situation? What's your thought in that? I've got very clear views on that, and I'll thrust them upon you shortly. What are your thoughts? Good, bad, and different.
I wouldn't really recommend it. I mean, I think that it puts them in a position where they're acting really for their own benefit because they're usually beneficiaries as well. I mean, if there's an independent trustee in there and they insist, well, maybe, but yeah, I wouldn't normally want it to happen that way.
Yeah, no, look, I form the same view that not just I wouldn't recommend it, I recommend against it.
Yeah, well, that's what I'm saying.
Because I think that there are different generational objectives. And I've seen some where the parents want just the children to be trustees. And I said, look, you've got some serious problems here because you're giving them authority to deal with the trust as they think fit. And there's no guarantee they're going to highlight your interests as being paramount. And that even if they are obliged to treat your interests as paramount, they might not do so. And although you might retain the power to appoint and remove trustees, it could be shutting the gate after the horse has bolted. But it's a horses for courses thing, but generally people will say, oh yeah, actually, yeah, makes sense, I won't do that. There can be concepts where they do bring on children from time to time to introduce them to the concept of the trust, so that as part of the succession, the children will come on as trustees. In that context, though, I'm probably more inclined to adopt the thing you were talking about before, perhaps bringing children on as an advisory trustee in that regard, so that you're introducing them to the management of the trust, the culture, the style, what it does. They have to be consulted by the trustees. Then whatever the advisory trustee says or does falls by the waterside, because you don't have to do what the advisory trustee says, but you get them involved in the process. So there are, many ways of dealing with, depending on what the family dynamic is. You'd always be particularly concerned if a family was bringing on perhaps a son-in-law as a trustee or something. That said, I am my parents-in-law's independent trustee because I've cut myself out of the trust completely. But I'm the independent trustee because I'm their lawyer as well. I have certain obligations and they can take me to the Law Society if I misbehave. But other people haven't got that same luxury. So I think you've got to be wary of that conflict of interest issue. Not to earn unauthorised profits from the fiduciary office. You probably recall from your basic days that trustees cannot profit from their job. How do we manage that? Well, we contract out of it. We have to include charging clauses. But you'll also notice that if you read some of your trustees, there are probably clauses in there that say that if a trustee happens to be a director or something of a company with which the trust deals in a transaction, that person can still keep or earn their funds as director or whatever. Because these days, that sort of thing happens a lot. You might have a trust leasing property or buying something, or buying is a bit more difficult, but leasing or doing something where there's an involvement. So there will be a profit coming through. Not to deal on one's own behalf with trust property on pain of such transaction being voidable. It always reminds me of Blackadder when you talk about, it's almost on pain of death, isn't it? Not to deal on one's own behalf with trust property. So not to deal with it for yourself. And that's a bit, isn't that the sort of like the self-dealing type aspect? And how do you manage that situation where you have mother and father as trustees, lawyer with the corporate trustee as the independent, and the parents thinking, okay, we want to go on an overseas trip, we need 30 grand for that. How do we deal with that one? Because if we're distributing funds to the trustees who are, or beneficiaries who are trustees, aren't we then acting on one's own behalf in a transaction? So you need clauses in your trust deed to deal with that. Dealing fairly with trust property. We're all familiar with these sort of concepts. Everything we do, we have to be reasonable and be fair and whatever. This is the interesting one. Preserve the confidence of the beneficiaries. That's tricky, and it's going to get trickier as we go. what was it? It was the recent case of Green and Green, which was very messy, and it's probably still going on in the background somewhere. But one of the situations there was that there was a long-standing lawyer of good repute who was one of the trustees and also solicitor to the group. And when before Mr. Green died, and there were some changes promoted to all of his affairs, which led to all the litigation, a different lawyer was brought in to deal with some of the issues, and that was, I think it was Winkleman Jay said that she thought that was somewhat irregular, that such substantive changes were being dealt with absent the long-standing lawyer who knew all the background details. But it was also commented that this particular long-standing lawyer was very good at his job in that he was able to make his decisions but not to fall out with either side of the fence, of the beneficiaries or the trustees. And I think that's probably a highlight of the epitome of perfection in that regard, that he could probably make it sometimes hard decisions based on perhaps business acumen plus based with trust decisions, that he could still preserve the confidence of both parties, both trustees and beneficiaries, and all beneficiaries, even where the beneficiaries were fighting, on the premise that he wasn't favouring anybody, he was just being objective and down the middle. And that's one of the things we have to be very careful of what we do, because we are going to have more and more beneficiary disputes and have to be wary that we're not being suggested to aligning ourselves with any particular party, which can be difficult. But it's something where we need to be aware of. In that case, it comes back to the conflict of interest issue. If we act for one of the beneficiaries in their personal circumstances, and then a dispute arises between that beneficiary and another one, it's not too hard to point the finger and say, actually, you're not being impartial, you're not dealing fairly because you have an alignment with this other beneficiary because you act for them. And that's probably not an unfair call. So in that case, you need to be aware of the conflict of interest and perhaps remove yourself from acting in a particular circumstance.
Which was difficult because it runs counter to the, in those days where, you had the trusted family lawyer that was, multi-generational.
Yep.
And it was just a safe, wise person to go to. It's,
But that's the change in social attitudes. And it used to be that people would put on their Sunday best to go and see the lawyer. These days it's like straight from the beach in their board shorts and shirt and their jandals, but the lawyer can't be dressed like that because they've got to be wearing the shirt and tie and coat, because that's what lawyers do.
You should see our clients in Warkworth. They think because they're all farmers that they can just arrive without an appointment, gumboots, shorts, the whole lot.
I can well
lovely
imagine.
People, really lovely people.
They probably pay you with sides of lamb and beef and chicken and eggs.
Possibly,
Yeah.
I don't know.
Yeah, but that's the change in attitudes that people are now more questioning. And look, it's not an unfair thing, but it's almost going too far in that pendulum of fairness. People are now, I think, being influenced by personal entitlements or false sense of entitlement. They're entitled to get something, and although the lawyer may have acted completely appropriately, it's the tainting of the issue. Is there a perception that you may be unfair or you may be aligning yourself with one person? That's the problem that we have on a daily basis. And when it gets to court, we're subject to the counsel of perfection by a judge sitting back in their ivory tower saying, well, it's pretty obvious to me that because you've done that person's their conveyance, that you had an alignment with them and there was subliminal bias in their favour. We can't win in those circumstances, and it's a question of being alert as to what the concerns could be, because people are becoming more and more litigious.
It makes it more expensive at the very beginning because you send everyone off to various new lawyers who then will see the documents and then give their different opinions, and it just
Absolutely.
escalates and becomes...
It can become a feeding frenzy, but people need to be aware of that. But sometimes it's better to have a bit of a cost up front and have it all resolved rather than have issues afterwards. Preserving the confidence of beneficiaries. Accounting and providing information. Well, we've touched on that. This is the new exciting aspect there, isn't it? Ursig and Ursig, Kane and Hutton, Rosewood and Schmidt. What is a trust document? Who gets what, when and why? And if you don't provide it, who pays for it? That's the scary thing. That's the scary, and that's where the threats always come through. Those Bill Patterson type letters. If you don't produce it to us, you'll be personally liable for costs.
And your response?
Oh, you throw back the cases then. Commercially sensitive. You're just on a fishing expedition. You've got no right to it. But then you crank up a few $1,000s in fees backwards and forwards like that, playing technical games, and see who blinks first, with the client's approved instructions, of course. And then take into account relevant considerations and to overlook irrelevant considerations. A lot of this seems very touchy-feely and obvious, doesn't it? But they're the sort of things that will come back to haunt us in due course. What's a relevant consideration, or what's an irrelevant consideration? You can't write rules for that. It's a question of at the time, isn't it? And then that comes back to, well, you're entrusting the person to be the trustee to exercise their discretion. If you can't trust them to do that, why put them there in the first place? So we've dealt with the operative parts of a trust at the stage, or the concepts, the dispositive provisions, and the management and administration. And now we have to look at the legislative influences that affect how we draft trust deeds. Before we do that, are there any questions or feedback about those boring dispositive or administrative provisions? Because they are, in essence, the guts of the trust deed. Are there any situations where you've found where there have been problems with that, or incomplete provisions, or from a practical perspective? Is it something you've come across where there's been a problem?
The one that I come across most is the lack of power to resettle
Right.
when the trust is just not working for them.
Yeah.
Because of restrictions and the resettlement. Sometimes you get, well, there is no resettlement clause.
Yeah. And what do you do in that situation?
Make a distribution back to make a distribution to the beneficiaries.
Because I think there are two possible other scenarios which aren't great but possible, because there's an inherent power of resettlement under the Pilkington provision, as long as you can fall within the right parameters there. And there's also the statutory power of advancement section. There's a 41A of the Trustee Act, where you can advance up to 50%, provided that the limitation has been removed. So it could be you can, over time, resettle half and half and half and half and half. But yeah, otherwise you are left with some interesting situations. Resettlements.
No power to vary it.
That's the way I struck, yeah.
Okay. How would you consider the power of amendment or variation? Dispositive or administrative?
Dispositive.
Administrative.
Well, I guess it could be either, depending on what you want to do. Can't think of the situation that it was.
On what you would do, what was what had triggered the reason to vary?
I think we touch on that a bit later, but I think it falls within the administrative aspects, and it's got constraints as to what the power of variation can do. The general principle underlying a power of variation is that you can amend or vary the trust deed to give effect to the original intentions. If there's a change in case law or statute or circumstances that means that you can't continue with your original perspective, you can change the trust deed accordingly, but really you can't change the trust deed to give greater dispositive powers and to introduce new people to the trust, because that would start to detract from the original intention. So we do touch on that a little bit later, but I think it falls within the administrative provisions. The resettlement clauses these days, they used to be really important because there were potentially duty issues involved. And it was the major case in that one was the IRD and Gray, which is one of the ex-All Blacks, Ken Gray. And there were questions of whether the class of beneficiaries of the new trust to whom the resettlement was to be made was significantly greater or different from the original class of beneficiaries, and therefore constituted a new settlement and therefore a new trust which would trigger estate or tax issues. And in those days it had to be a question of making sure that the resettlement provisions, that there was a sufficient commonality of beneficiaries between the two trusts. Some resettlement clauses would prohibit the inclusion of parties not in the current trust to be beneficiaries. And it might be that the resettlement in that case was maybe for a grandchild for some reason, and they would generally be within the classification of beneficiaries because they would be issue or remoter issue of the children of the settlor. But sometimes the resettlements were for a child and their spouse, with the spouse not being a beneficiary of the existing trust. And the question was, does that compromise the integrity of the first trust and take the resettlement power outside of the hands of that trust? Because you're letting in effect, new blood into the trust. So it was a question of the terms of the resettlement clause as to how far it could go. And these days you'll find that modern trust resettlement clauses will say that the resettlement can take place for the benefit of any one beneficiary, even if other people who aren't beneficiaries of the existing trust are potential beneficiaries of the new trust. That's not an unusual feature to see, because there are no tax implications these days. The implications arise in the advice aspect that if we're doing this resettlement, you need to realise that, Johnny, that if we're resettling trust from your parents' trust across to the trust for you and your wife, what was once your inheritance and your separate property and safe from your wife if there's a breakdown in the relationship is now becoming, in effect, joint property and therefore vulnerable to division. And that's the advice aspect as opposed to the actual resettlement provision, which is what a lot of people don't actually think about. They say, oh yes, we can resettle, and they don't think of the subsequent implications. So again, going back to the core principles, yes, we can do it, but is that something we should do? Or as you said, sometimes the clauses aren't sufficient. It might just say you can only resettle to a trust of which a beneficiary is a member. Beneficiary of the first trust is a beneficiary, and no outsiders. Horses for courses. But older trusts tend to have their problems. Modern trusts seem to have a revolving door each way you can go. You can swing one way, the other way, but it's the advice aspect which becomes important. So what did I get to here? The legislative influences that affect trusts. That's correct, Sean. The government is comprised of 5 branches: the executive, the legislative, the judicial, lobbyist, and the media. And I think that's about right. Do you recall a few years ago when Rod Petricevich, Mr. Bridgecorp, was having a few problems and he was after some legal aid? And the argument that he was propounding was that he was neither a trustee nor a beneficiary of a trust and therefore had no access to funds and was entitled to legal aid. And the decision came out that he was not entitled to legal aid because his wife was a trustee and a beneficiary, and therefore he could simply ask her for money and therefore he'd be okay. Socially, the judge's decision was correct. Technically and legally, it was absolutely wrong. But that's what we have these days. We have a social justice versus an actual legal justice. And I recall I was asked by a journalist to comment, and I said, nah, not me, because I know the answer, and I know what's right at law, and I know what's right socially, and I don't want to be the scapegoat for that, because these are the days that we live in. And I didn't like what he'd done as well. And I think there could have been some different legislative changes that could have solved some of those problems on the premise that I'm picking. And I haven't looked at Bridgecorp closely, but I'd imagine what happened was that, probably the same for some of the blue chip companies as well, is that Mr. Petricevich would have been a director of some of the companies that declared significant dividends to trusts of which he was not a trustee or a beneficiary. But there must be some sort of a concept of knowing receipt that his wife probably, or he knew that he was transferring assets to trusts and that the funds were ill-gotten gains, and that must taint the receipt. And I wouldn't have thought it would be too hard to get some sort of legislative amendment to deal with that, but that's not the way it went. So that's one of the examples where the social media or the social justice kicks in, and judges are forced to reach decisions that are socially acceptable rather than legally correct. And some of the principles that have been derived to support that is extraordinary. Any other examples of sort of social justice that you can think of?
Cases that are
Yeah, I
trumping
was just thinking
equity.
that.
Well, I always think that the bundle of rights was one of those. And that was, of course, the legacy of the late Justice Chambers, and strangely enough, who was married to, at that time, just a barrister, Lady Deborah Chambers, who was doing PRA work. And the whole concept of the bundle of rights is anathema to trust lawyers, because it's bastardising the principles that we've known and loved for so long. But it's changed, and although bundle of rights has been pushed out, we've now seen in Clayton that it's had a bit of a resurgence, in that if you have certain rights and powers, they equate to the value of trust property. And it's just another way of the courts trying to find a way around modern situations.
And that's what Clayton and Clayton seemed to be to me. It was like it was more a social decision rather than a legal decision based on what was correct in terms of trust.
Look, I think there are some issues. I think that a trust formed during a relationship, which doesn't include the spouse, I think is destined for the courts, because that's just a problem. But other principles I think are wrong. The fact that the Supreme Court even said that the fact that Mr. Clayton hadn't exercised certain powers, the fact that he could do so was enough to damage him. I haven't murdered anybody. I could murder somebody.
Yeah.
You know, where do you draw the line? I could steal from somebody, but I haven't. I've got power to do so. It's the social justice coming through, and that's what we have to deal with, which is why I think as trust lawyers we have to be vigilant, because we're not just dealing with legal principles, we're dealing with potential social justice issues and how that can impute what we do. And so, absolute fairness is something we need to maintain. And, if you have I had a client recently who was setting up a trust, and I sent him all the information. He said, "Oh, do I need to involve my wife?" I said, "Yep." Simple as that. Yes, you do. Because otherwise you're going to be in trouble. I've other clients, and he said, he's quite a few years older than me, but he said, "But these are my assets because it's my business and I built them up and I did all the work, and she played tennis and bridge and whatever." I said, "That's fine, but that's not what the law says." So they're the sort of issues we have to be aware of, and sometimes we have to make some pretty hard calls, which are pretty unpleasant. I recall doing a will for an elderly woman, and she had a friend. He was in his 80s or something, and both quite vibrant, if you know what I mean. And he was staying at her place, and I said, "Oh, do you realise we've got some implications here?" She said, "What do you mean?" I said, "Well, the Property Relationship Act suggests that depending on how many of these little boxes you tick, you might be deemed to have a de facto relationship, and if either of you dies, the other of you might have a claim or vulnerability to the other." So having a discussion with an 80-year-old woman about her sex life, a bit uncomfortable, but had to be done. But good on her. So they're the sorts of things that we have to bear in mind. And it's interesting that as a trust lawyer, we're sometimes maligned that all you do is deal with dead people, because they usually say trust and estates and think it's all just death. But we actually get to find out some really, really interesting family circumstances. We get lots of dirty laundry that comes out. And we actually become trusted advisors to our clients. And because we become trusted advisors, we can do a better job. But it also means we have to be more circumspect when it comes to dealing with conflicts of interest and things like that. So it's a fascinating area, but we need to be aware of the influences that affect us in what we do. So I think that's probably a good stop before we jump into the next aspects there. Let's just have another quick water break or so, and we'll come back in about 5 minutes.